Hello, everyone. Welcome to Court with Krissy. Another vexatious pro se in small claims court. This time, this one's in a protected class. I think most of America's in a protected class. Just watch it. I hope you like it. Court with Krissy is now in session.
All right, the next matter is Jeff Hodges versus Megan Sheldon. It's file 25-40686-GC. Who do we have present for this case?
Jeff Hodges.
Good afternoon, Your Honor. Matthew Kassar, P83663, here on behalf of the defendant, Megan Sheldon.
All right, thank you very much. And do we have, anybody here for Jeff Hodges?
Yes, I'm here.
All right, I do see you now, Mr. Hodges. Thank you very much. This is a motion for summary disposition filed by the defense. I'm going to give each side an opportunity to tell me why they believe that their side should win. Counsel, go ahead.
Your Honor, just so I can clarify, I think today, I'm happy to go forward. We did file, Ms. Sheldon filed a motion for summary disposition. It is set for hearing July 14th. Just to comply with the court rules, the 21 days. This was the date and time set for a pre-trial. Again, happy to go forward with arguing the motion for summary disposition, but per the court rules, we had to set the hearing out 21 days.
I see that now. Thank you for bringing that to my attention. Mr. Hodges, did you understand what he just said?
I don't know the procedure.
The procedure is if they file a motion such as he's filed called a motion for summary disposition, that is a motion that says we win by virtue of what the law says, they have to give you 21 days to respond to that. And that would be on July 14th. It's already set for a hearing then. So 2 weeks from now. However, if you want to, you could allow that to be heard today and we would just cancel the hearing on July the 14th. If not, we'll probably just come back on July the 14th and we'll argue it then. What would you like to do, today or on July 14th?
I prefer to see what can be solved or not solved today.
Okay, so you want to go forward today and,
yes,
and not have the hearing on the 14th, is that correct?
Yes.
Okay, all right. So I'm going to give both of you again an opportunity to argue your sides and to put out whatever information you want me to have. So counsel, this is your opportunity. Go ahead.
Yeah, thank you, Your Honor. This is, I trust that the court received the briefs and the motion. This is one of several actions filed by Mr. Hodges in the wake of his termination as a contract worker, ultimately for the end client Wade Trim, Inc., which is a professional engineering firm. Mr. Hodges filed several actions that we believe are frivolous. This is one against Mrs. Sheldon, who was a remote supervisor of Mr. Hodges during his 3 or so weeks as a contract worker. Mr. Hodges was terminated for performance purposes, performance concerns. He was an at-will employee. He was actually terminated from it's called Act Talent, which is a staffing agency that Wade Trim uses to staff some of its engineering projects. This was filed initially as a small claims matter. There's a short affidavit with half a paragraph or so of allegations that are vague, conclusory, do not state a cause of action, and do not state any facts that would support any cause of action under Michigan law. So Ms. Sheldon moves under MCR 2.116C8 and 10. Mr. Hodges' claim, if there is a claim, if there is a cause of action, fails as a matter of law for all these reasons. There's an affidavit from Ms. Sheldon in support of the motion for summary disposition. And I will note, Your Honor, that because Mr. Hodges has not responded, ordinarily, in order to defeat a motion for summary disposition, you would need to respond with an affidavit or evidence of his own to rebut the arguments that are stated in our motion for summary disposition. That hasn't been done. Again, I'm not sure that there would be any reason to do that because, again, there's no cause of action. What it suggests is a wrongful discharge, but he was an at-will employee, not even an employee of Wade Trim. He was a contractor, and at-will employees can be terminated at any time for any reason or no reason. We go into our briefs, and I'll just be brief, no pun intended, but be brief. If there was a cause of action for fraud, that hasn't been pled because all the elements have not been established. If there's a cause of action for intentional infliction of emotional distress, that too fails under Michigan law. And if there was a cause of action for wrongful discharge, as I stated again, under Michigan law, that's not viable. For these reasons, we request that the court dismiss this case. Um, and that's it. Yep.
All right. Mr. Hodges, how do you want to respond?
First, I'm aware of the at-will law, but my termination is illegal because I'm a protected employee under the federal laws, and I clearly state so. Seems like the other end has problems of the comprehension, so that's problem one. So I filed a small claim lawsuit against Megan Sheridan for her deceptive action to lie to me for a meeting 2 hours away to drive that incurred significant travel expenses on the last day of the snowstorm here in Michigan. And potentially criminal activities has occurred because after I was unwilling to settle initially, someone in Wade Trim made a false accusation on me, accusing me as a terrorist, trying to get me arrested. And the police report is available in Kent County Sheriff Office. And the CFS number is KSP-0123167167-2025. But of course, the prosecutor see the content is nonsense, so they decline to press the charge. And through this process of the bogus, baseless attack to fabricate me as the terrorist, online stalking has occurred. So as an additional discouragement of further actions like that, because someone in Wade Trim stalked me online, collecting information, and that includes the CEO of the Wade Trim. So I have to file additional lawsuits to the CEO directly himself to discourage future escalation of the harmful activities against me.
Your Honor, may I respond?
Sure.
So I want to respond to each point made. First, Mr. Hodges, one, did not plead that he's a protected class, and two, there's no evidence obviously offered that he would be a protected class. There's nothing that would suggest that he was anything other than an at-will employee. Also not an at-will employee of Wade Trim or Ms. Sheldon, who's the defendant in this case, which was just one of his remote supervisors. Two, he said he incurred travel expenses on the day that he was terminated. If he did, he was reimbursed for everything, and these proofs are in our papers, so that allegation does not hold any water. And three, the quote unquote accusation of Mr. Hodges as a terrorist is not true. If you look at, I believe it's Exhibit 2, the Miss Sheldon affidavit. Exhibit A to Miss Sheldon's affidavit is a compilation that Wade Trim's Human Resources Department collected of Mr. Hodges' public LinkedIn comments that indicate that he is notorious for filing lawsuits and also has several threatening and violent comments against employers and supervisors and the like, which is why Mr. Hodges was reported to local law enforcement as Wade Trim's Human Resources Department was concerned for the safety of their employees. And as you mentioned, filing a lawsuit against the CEO, that is also a lawsuit pending before Your Honor. And we have also filed a motion for summary disposition in that case and seeking sanctions for filing frivolous cases against Wade Trim and its employees. That lawsuit obviously is not up for today. It's coming for hearing on July 21st, but we will be seeking the same dismissal and also costs and fees in order to have to defend against that case. In addition, Mr. Hodges filed a petition for a personal protective order against Mr. Andrew McCune, who's the president and chief executive officer of Wade Trim. This is also a frivolous filing, also requiring Wade Trim, Mr. McCune, and Ms. Sheldon to incur legal fees by way of a frivolous lawsuit. Again, there's no cause of action here. There's no facts that would support a cause of action, and it requires, and there's no evidence to rebut the now unrebutted evidence attached to our briefs that establishes that summary disposition in favor of Ms. Sheldon is proper.
All right. Mr. Hodges, what information do you have to support your claim that you are a protected individual under federal law?
In the email communication, I told, who was it? Megan Sheridan, that I'm a protected employee. And due to the underlying reasons for the protection, I need the reasons to notify them. And because of the email correspondence, since April, I was terminated because of this. And
I still haven't heard you tell me why you're a protected individual. What status do you have that would allow you to be protected under federal law?
I'm protected under American Disability Act due to various disability conditions. Thus, I have
such as what?
Where such as this. So I need.
Have you submitted any of that documentation with your responses to this court so that I can determine whether or not you're a person that has a disability?
How should I submit the information?
You do it the same way you sent in information on anything. You filed a complaint with this court. That's when you put in. That's how you put in the information. You drop it off at the court, or you mail it. However you got the original information here, that's how you get that here. So okay. Have you submitted any documentation to support your disability claim?
They are here on my side, but not on your side yet.
Well, there's nothing I can do about it. You haven't submitted it. You haven't sent it into the other attorney. You haven't sent it into the court. So there's nothing that I can look at to determine whether or not you actually have a disability claim there. Just showing me a pill bottle and papers doesn't do any good at all.
Given that situation, I do have some additional information here. I don't know how visible this is.
It's almost invisible. I can't tell what it is at all.
Okay, fair. Then I will not try that. Is there a way to request a hearing at a later date after I submit the information related to this?
Well, tell me what that information is going to be, and I'll make a decision about that. So what is your claim for disability?
Because I informed them that I have underlying disability falling under ADA. And
that's a conclusion. That's a conclusion, sir. I don't want a conclusion. I want you to tell me what facts you have that prove that you have a disability of some kind.
Okay.
You have a doctor. Do you have a doctor telling you that you have a disability?
Yes, I do.
And the doctor says that you can't work, or that you have limitations or restrictions on your work?
Yes. And
who is that doctor, and what are the limitations or restrictions?
I need accommodations in the hours so I can attend to the necessary medical appointments I need.
Who is the doctor, and what are the limitations?
Where my psychiatrist, like Angela Schutte, the psych nurse, and my psychological therapist, Daniel Shefford, and I need additional psychological evaluation to make further determination of the condition, to make better treatment.
Then you don't have a disability if you need further confirmation of that. That you might want to go for a disability, but you don't have one right now. Do you have a disability from a doctor that says that you cannot work, or you can only work with limitations?
I have that.
Where?
The disability is established, and it was diagnosed of me as early as 2018. And that's the record I always have. And that's the record I always inform the employers that I have a disability and I need accommodation.
So that's step number one. So I'll keep that in the back of my mind for a minute to determine whether or not we need to have a further hearing on your disability. The next step is, even if you had a disability, how is Ms. Sheldon the one who fired you?
Where I told her I have a disability and I have to let everyone know I have a disability so the hours can be accommodated. And upon telling her so, I was terminated as a result.
Who are you working for?
I was working for Waitrim.
The defense has said that you were working for a temporary firm by the name of, was it Activent?
Yeah, where I was working for Waitrim through a firm, yes.
You might have been working at a Wade Trim job site,
Yes.
but what evidence did you have to prove that you were working for Wade Trim?
Where the payroll comes from the firm that is excellent, but I reported directly to Megan Sheldon.
I'm not asking who you report to. I'm asking who hired you.
Excellent.
Ms. Sheldon worked for Actilent?
I don't know who she works for. Probably with Trim or wherever the payroll comes from her.
Well, the defense has said that she works for Wade Trim and not Actilent. So if you work for Actilent, why should you be suing Ms. Sheldon?
Because Mr. Sheldon is the one conducted deceptive actions on me and terminated me.
She didn't terminate you if she didn't employ you.
Then I don't know how that works.
I'm sorry that you don't, but all I can tell you is you can't sue somebody for doing something that they can't do. If Ms. Sheldon is not your employer, she can't fire you. Your employer fired you. Your employer right now is Actilent, as far as I can tell.
Then they never fired me. They did not say they fired me. They just want to stay away from this problem, and they told me they didn't do anything until it gets pretty chaotic.
Then what's the problem? Why should I have a lawsuit against Ms. Sheldon if you were simply told to stay away? You're employed by Actilent. They can tell you to go wherever you want. They want you to go, can't they?
No, so that's why I received the COBRA letter, so that shows that the termination of the employment. Then because Megan Sheldon did the decision of termination, so
how can Megan Sheldon make a decision to terminate you if she doesn't work for Actilent?
I don't know. The termination decision comes from her in my perception.
Your perception doesn't mean a thing right now if she doesn't work for Actilent. You've told me that you were employed by Actilent. The defense tells me that she's employed by Wade Trim. Do you have any evidence to dispute that?
I don't.
Okay, then based on that information, then it really doesn't matter whether you've got a disability or not. Your lawsuits against Megan Sheldon, there's nothing that she did or could have done that would be viable in a lawsuit if it's a termination of employment process. That's all through Actilent. You're going to have to sue Actilent. Megan Sheldon's got nothing to do that. Counsel, did you submit a proposed order in this case yet?
Oh, we did not, Your Honor. We can submit one today, though.
All right. Please do so, indicating that I find for the defense for the reasons stated on the record, and I'll sign that once it's submitted here. Thank you very much. All right, that's all for today.
Thank you.